Hey, I'm bankruptcy attorney Matt McCune. Welcome to the Bankruptcy Show, the show your creditors really don't want you to watch or listen to. We're going to break down the facts about debt and bankruptcy, showing you what your legal rights really are and giving you the information that you need to take care of yourself and your family. Let's get into today's episode. All right, a lot of people have questions about the process of what happens after you file a bankruptcy. So in episode 7, I'm going to talk about the process for Chapter 7 and Chapter 13. The process is the same up to a certain point, the meeting of creditors, and then it kind of splits from there. So first and foremost, right, got to, make the decision to get some help and talk to bankruptcy attorneys, and I can always help you put you in touch with those people. But so let's say you have found your lawyer, you've kind of gone through whatever onboarding process that law firm has, submitted your documents, which can be a bit of a pain for everybody. We're building a product that's going to make that a lot easier. But you've gotten your shit to the lawyer, right? And the lawyer's staff has done, the paralegal or the attorney or whatever, they've done their thing, and you're ready to go. So you're going to meet with the attorney or staff from the law firm. We do it on Zoom in my office. But then we have to get the signatures later. But yeah, these are small law firms. A lot of them have some fairly poor practices that are inefficient, but it is what it is. So you sign off on the documents, and then the case gets filed. Boom, you're bankrupt. Congratulations. You got a case number. You're under protection of the bankruptcy court. Something called an automatic stay has taken effect, which really means your creditors are stayed, prevented from fucking with you, right? Foreclosures, repos, lawsuits, harassment, all that sort of stuff terminates with the automatic stay taking effect once the case is filed immediately. Now, most of the big banks have signed up for electronic notice from the bankruptcy court, so they'll get notice right away. Some of the smaller creditors, it's not like the phone calls and the letters stop instantly, right? You typically have to give it a few weeks. By the time you have your meeting of creditors, which is the next big step after the case is filed, typically the phone calls and the letters and all that sort of stuff should be wrapping up. And if you're continuing to get harassed by creditors after your case gets filed, you need to let your lawyer know, because that's what's called a violation of the automatic stay. And man, I love to sue creditors for that. We get a little bit of cheddar out of them. No one's getting rich, but pretty much people keep harassing you. Give them the case number. If they keep doing it after that, give them the case number again. Make a good record. Like if it's a text, keep a screenshot for your lawyer. If it's a phone call, write it down. That sort of stuff. Because the bankruptcy courts, the judges say that we have a duty to mitigate, which means when the creditors continue to harass you after the case is filed, you kind of have to give them multiple warnings, basically. Now, there's a really good lawyer around here in Colorado, Matt Osborne's his name. He says you got a duty to litigate. So I fall somewhere in the middle. I do sue creditors for stay violations, but typically we won't do it unless we've really given them plenty of notice. And at some point it's like, all right, fuck you. We gotta sue you, man. And then they write a check and finally go away. So you get your case filed, protections in place. They can't foreclose on your house. They can't repo. They can't sue, garnish, harass, etc. Right? The next big step, whether it's a Chapter 7 or a Chapter 13, is what the Bankruptcy Code calls a meeting of creditors. It's Section 341 of the Bankruptcy Code. So when you hear your lawyer talking in our circles, we'll refer to it as a 341 or something like that. MOC. It's kind of mistitled because it's unlikely that any of your creditors are going to be there. The bankruptcy trustee will be there. You're always going to meet with the bankruptcy trustee. But it should be called a trustee meeting, in my opinion. But your creditors are given the opportunity to show up and question you. And this, for most people that go bankrupt, this is the one hearing they have to go to. And for most jurisdictions in the nation since COVID, this shit is on Zoom. It's the single greatest time to ever go bankrupt in the history of the United States, people. It's never been easier. You can go bankrupt from your couch, never leave your house. So I got my case filed. I'm now meeting with the bankruptcy trustee. If it's a Chapter 13 trustee, that's who I'm meeting with, or a staff member for the trustee's office. If I'm in Chapter 7, I'm meeting with a Chapter 7 panel trustee. There's all these players. I've explained that in some of the other videos, and we'll dive more into these who's who in the bankruptcy world in coming videos. But, I get my case filed. I catch some breathing room, right? A month later, I got to meet on Zoom, likely, with the bankruptcy trustee. Your lawyer will be there with you. They're going to need new pay stubs and new bank statements that come in after the case gets filed. And so make sure you're paying attention to requests from your attorney's office and getting them that information. So the meeting of creditors is really kind of checking a box, right? Your creditors are allowed to show up and question you. They're not going to, like I said, for the most part. 98% of the time, it's you, the trustee, and if it's a Zoom room, it's full of other debtors and their attorneys. So the bankruptcy trustee is required to ask you specific questions. Really, they're asking about assets, they're asking about debts, they're asking about income, they're asking about expenses. In a Chapter 7, the trustee's primarily concerned with, do you have any non-exempt assets I can take, right? The Chapter 7 trustee has a huge incentive to liquidate non-exempt assets because he or she gets a cut of whatever they collect. The Chapter 13 trustee is a little bit different. It's more of a pseudo-government salaried employee, but it's pretty much the same process. If you've been properly prepared and your lawyers got their shit together, which doesn't happen all the time, the hearing shouldn't take longer than 5 minutes. Now, what happens if a creditor does show up? Well, they are allowed to question you, and that can happen from time to time, and the hearings can drag on. But again, that's just not the average case, and it's the exception to the rule. So I got my case filed. About a month later, I went to my trustee meeting, the 341 meeting of creditors, 7 and 13. And it's the same process for whichever chapter you're in, whether it's a 7 or a 13. But after there, that's when it's split. So let's talk about Chapter 7 first. So after the meeting of creditors, which is a month after your case is filed, right, we then wait for 60 days, right? We're waiting to get past the deadline for your creditors and the government to object to you getting a discharge in a Chapter 7. And there's a couple different deadlines in there. But basically, it's just, if we can get past 60 days and no one has thrown any wrenches in the system, you're going to get your discharge. So creditors can object, fraud, that sort of stuff. I know we talked about that before. And then the U.S. trustee's office will object sometimes in a Chapter 7 if it would be a substantial abuse of the bankruptcy system to grant a discharge to the debtor. And that's like if your income's too high, that sort of stuff. So, you kind of hold your breath for about 2 months after the trustee meeting. If the trustee in a Chapter 7 had requests for documents, sometimes it's going to be taxes, that sort of stuff that come in after the case got filed. You do still need to comply with the trustee. But in a 7, you file, you do your song and dance with the bankruptcy trustee, you wait for 60 days, you make sure that 60 days you got your second class done, the debtor education requirement. And then, kind of cool. 3.5, 4 months after a Chapter 7 is filed, a piece of paper showing up, says discharge on it, wiped out a bunch of debt. Taxes, child support, student loans, not going to go away. You knew that already. If you have other issues, we typically call that litigation adversarial work in a bankruptcy, or issues with the U.S. trustee. Shit can get derailed, and that's when you hope you hired someone good. But that's the 7, right? Now, if you have a potential asset case, just because you get your discharge does not mean it's over, and that's super important to be aware. If you have, and usually it's your tax refunds that are coming in, and we're at the end of the year when I'm shooting this, and so this is coming up a bunch right now. So, you might have to turn over a portion of your tax refund to the bankruptcy trustee, and so while you get your discharge, the trustee can keep your case open to liquidate assets of the bankruptcy estate. So, and that does happen from time to time, but it's really not a lot for you to do. So the case stays open much longer in that instance. It doesn't close. But when a bankruptcy case closes, you don't even get noticed of it. It's just an entry in the bankruptcy court's docket. It's the discharge that you're really looking for. But remember, if you've made a promise to the bankruptcy trustee to, provide some information or turn over certain assets or whatever, you have to follow through with that. Because the bankruptcy trustee can revoke your discharge. That's the nuclear option. If I go bankrupt and I get a discharge, but then I think, fuck you, Mr. Trustee, I'm done cooperating with you. You can't have my tax refund. I'm going to blow it. The bankruptcy trustee can get your discharge revoked. And if I got my discharge revoked in a bankruptcy, I can never again come back into the bankruptcy system to discharge that debt. It can't go away. It's like non-dischargeable. It's the nuclear option. It's not ideal. Avoid it if you can. Cooperate with the trustee. Okay, so that's 7, much simpler. Chapter 13, much more complicated. Okay, the confirmation process to Chapter 13 typically lasts a total of 4 to 6 months on average. It can take about 3 plans to get a case confirmed. And you file one plan with your initial filing, most likely, and then you do your 341, and now what comes after that? Well, there's a bunch of deadlines. There's what's called a proof of claim deadline. It's kind of hard to get a Chapter 13 confirmed and wrapped up unless we know, where all the debt lies. It's way more complicated. So what I'll do in my office is always file a document with the court that says, hey, judge, we filed a plan. Most likely you're going to get some objections. We're going to try to resolve those objections in a second plan. But I want that deadline to be after the claim deadline. So when I go to file that second plan, I can see, well, what claims are in, what's the debt. I can try to solve all the problems much quicker. That wheel can spin 3, sometimes 4 times, where you're filing a plan, you notice it out, you get objections from the bankruptcy trustee, creditors, or whatever, and you're really just trying to move the ball forward and getting closer and closer to that confirmation point. 6 months a lot of times. And the payment can be changing during this. You start off at $500 a month or whatever. Typically your next plan, I always tell them, usually it goes up. It doesn't go down. You want to view your first plan as an offer. And, 13s are complicated, and your lawyer should have some strategy to this. But you start low and you kind of bump it up over time. But, issues pop up and things you might not be aware of, and you got to solve all of those problems as you're moving through a 13. But from your perspective, most of this work is being done behind the scenes by your attorney. You get the case filed, you show up to the creditor meeting, and then you're just kind of like, hey, what's going on? Your lawyer should be letting you know and keeping you in tune with what's going on. And a lot of times they'll be asking you for documentation, new pay stubs, new expense documentations, other things can be popping up. So there's these things, and each district is going to have a little bit of a different rule and process and how they do that, but there's a confirmation hearing that typically gets set each time a plan gets filed, but you don't need to go to that. The lawyers are going to go to that, and you'll know, your lawyer will let you know if you need to be there for these types of things. In most districts, that you don't go, and they don't even happen, because if you have objections, you file a document that says, hey, we're going to file another plan, like a third plan. Now we're really trying to solve these issues, Judge. And so by the time in Colorado, they want them resolved by the third plan, and the third plan should be confirmable, and most of the time it is, but sometimes you got to go into a fourth plan. The IRS hasn't been home for months, and so they're not filing claims, and if I owe taxes, well, I can't get a damn plan confirmed until I know how much I owe the IRS, and if no one's home at the IRS, it's really hard to get that figured out. So these things can happen and delay things. But in the 13, while confirmation isn't the end of the road, that's kind of the goal of the beginning stages of a Chapter 13. Because once your plan's confirmed, you and your creditors are bound by it. And if you're going to say, hey, I'm going to pay all my unsecured debt a nickel on what I owed them. I owed $100,000. I'm going to pay you $5,000 over the next 3 or 5 years. If you honor that, you get a discharge and they get wiped out, and all these other things you can do, save your home from foreclosure and save your car from repossession and all that sort of stuff. So the beginning of a journey into Chapter 13 is bumpy, right? I'm not going to lie. But once the plan's confirmed, for the most part, you're good. Now they can be open for so long, 3 to 5 years, that shit happens. Cars break down or people lose jobs. And then that's when sometimes a plan gets modified. Sometimes a case will get converted over to Chapter 7. But the goal is, if all things being equal, if everything stays the same, you get to the end of the plan. And then there's a flurry of activity that happens at the end. Like if you haven't, the trustee's going to confirm if you had a mortgage that you made all your mortgage payments. And, depending on which district you're in, sometimes there's a bunch of documents to file before the court will certify the case for that discharge. So, beauty of the 7 is, pretty simple, pretty straightforward for the most part. If you don't have non-exempt assets and you're eligible, of course that's what you want to do because you get it in and out. 13, a much more complicated process that can last a lot longer, but you can do a lot more with your creditors in a Chapter 13. So that's just the snapshot of how a 7 and 13 goes. Litigation could happen within that time frame as well. I think I'm going to do a show on litigation and adversarial work because that's interesting info that you need to have. But hopefully that answered the big picture bankruptcy process questions that you might have for Chapter 7, Chapter 13. Have a great day.